Atheists, agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government, love.
Welcome to the Politics Guys. I'm political scientist Michael Baranowski, an emeritus professor at Northern Kentucky University. My guest today is Lawrence Lessig, the Roy L. Furman Professor of Law and Leadership at Harvard Law School. Now, I've been a fan of his work on campaign finance for a bunch of years now, and this marks Professor Lessig's third appearance on the show, though it has been a few years since the last time we talked. And I'm really pleased to have him back on today for a conversation on campaign finance, but this time through the lens of a current case involving a Super PAC contribution limit initiative passed by an overwhelming majority of Maine voters in 2024 that was permanently enjoined by a federal magistrate judge and is pending appeal in the First Circuit. Professor Lessig, welcome back to the show.
Thanks for having me back.
So I thought before we get into Maine's 2024 Super PAC contribution limit initiative and SpeechNow versus FEC as well, we could pull back a little bit and you could maybe tell folks a little bit about why you started Equal Citizens in 2016 and what you hope to accomplish with the...
Well, I mean, literally 20 years ago now, it's kind of hard to recognize that fact. I was convinced by a friend, Aaron Swartz, that there was no reason to be working on the issues I was working on then, which was copyright and internet, so long as we had this deeply corrupted political system. I tried to resist his argument by saying, it wasn't my field. And Aaron said, "You mean as an academic?" And I said, "Yeah, as an academic." And he said, "Well, what about as a citizen? Is it your field as a citizen?" And I realized he had trapped me because I indeed did believe there was no real progress to be made, not just about esoteric questions like copyright, but about the most important questions that we face, whether it's climate change or income inequality or healthcare or whatever. None of those issues will we address sensibly so long as we have this deeply corrupted political system. So I began work then. He and I started a group called Change Congress. That then evolved into a group called Root Strikers. I'm kind of a serial entrepreneur for nonprofits, which I then spin off and other people take it and do the work with it. We had something called the Mayday PAC, which was a Super PAC to end Super PACs in 2014. And then after Mayday PAC in 2016, I thought it was important to emphasize that this was really a fight about political equality. The money was just a proxy for the inequality that we all face in a world where private money funds campaigns. But as well as money, you could think about gerrymandering as creating a kind of inequality or vote suppression creating a kind of political inequality. And so the more core idea that is motivating all of this work is to achieve what the idea of a republic is supposed to be, a system where the citizens have equal political equality and a representative democracy that reflects that equality. So that was the founding idea behind Equal Citizens and really the motivation for most of the strategic work we've done since.
Now, in the sort of the post-Watergate reform world, I think the basic idea, at least to me, is that government can limit contributions to candidates, but not campaign spending. And so the result is sort of that candidates have to take in money in these kind of little eyedropper amounts, but they have to spend it in sort of fire hose amounts. And I'm wondering how that basic sort of Buckley versus Vallejo distinction between contributions and expenditures, maybe how that served to set up problems that we're still dealing with today.
Yeah, so, actually the statute, the Federal Election Campaign Act, which Buckley reviewed, was quite an ambitious and I think deeply sensible statute. They came close to adding public funding for congressional elections. That didn't make it, but it established public funding for presidential elections. It tried to limit outside spending. It tried to limit the total spending of campaigns, recognizing that if you just limit contributions but you don't limit spending, you're going to create this kind of imbalance that's going to drive to raise money in other ways, which would create the kind of pressures that produce the corruption that all of us are worried about. So Congress passed that statute, and I think Congress genuinely thought there was no constitutional question raised by that statute, because to that point, the Supreme Court had never struck down a law on the basis of the First Amendment, a law regulating the integrity of political systems. And there's been many laws over the course of our history that did that. But in 1976, the Supreme Court, kind of Zeus-like, declared that there was a background principle that would govern which kind of campaign finance laws were constitutional or not. What's striking about the opinion Buckley versus Vallejo, it's 144 pages long, per curiam, meaning no justice signs the opinion of the court. They all presumptively do. And that per curiam never once tried to explain what the original meaning of the First Amendment was, or why the original meaning of the First Amendment entailed the type of restriction that they were then imposing on Congress as Congress tried to deal with the problem of corruption inside of our political system. But nonetheless, they kind of declared, here's the principle. The principle is corruption. If you're going to regulate political speech, the only justification for regulating it is that it creates a risk of quid pro quo corruption, a particular kind, a narrow kind of corruption, the kind of corruption that exists in bribery statutes. And so, armed with this new ruler for measuring whether a law was constitutional or not, it went through this massive regulation Congress had passed in the early 1970s and struck down a bunch and upheld a bunch. So it struck down any limit on spending because it said, there's no relationship between spending and quid pro quo corruption. The spending is just more speech, so there's no justification for restricting spending. In the context of limiting contributions, it said, well, there's a good quid pro quo reason to limit contributions because if contributions are unlimited, most people would look at that system and say, well, there must be some kind of bribery going on there, so they would lose faith in the system. So it was the appearance and the reality of quid pro quo corruption that justified limits on contributions. And then they upheld the presidential public funding system because they were like, this is just providing more speech. It's making it easier for people to run for office. So there's no restriction on speech, and so there's no reason to strike that down. This rule, literally exactly 50 years ago, it was January of 1976, became the basic test for all regulation of money in politics that's followed since. And we've seen endless efforts by the court to make sense of this rule. And it's really become a kind of disaster of a complexity as, legislatures or Congress try to figure out what kind of regulation they can pass, addressing what is the fundamental reality, which is people look at our political system and say it is deeply corrupt. I mean, Brennan, 2 weeks ago, the Brennan Center released a report evincing the public's attitude about corruption. And this is like the one issue all of us agree on. Like they had polling that found more than 90% of Americans look at various aspects of our system and call it corrupt. Now, what's striking about what Americans think of as, quote, corrupt, is that only a small segment of it qualify as, quote, corruption under the Supreme Court's test for what is, quote, corruption. And that, from my perspective, raises a really fundamental question. Like, who the hell is the Supreme Court to, define this conception of corruption when it has no relation, really, to what any framer of our Constitution ever thought they were doing when they passed the First Amendment or any supermajority in passing a subsequent amendment? It's just basically the Supreme Court's view of what a good system is. And it's like, okay, that's interesting that you have that view, but why do you get to impose that view on the legislature when the only basis you have for restricting what a legislature does is that we, the people, through our Constitution, have made that conception higher law? And I don't think there's any evidence that the conception the Supreme Court now polices campaign finance regulations with has any relation to what we, the people, ever said. So I think the whole enterprise is illegitimate. And my view is if they were consistent in their originalism, I just circulated a paper titled If Roe, Then Buckley. And the argument was, if Roe versus Wade has to be reversed because it has no relation to the original meaning of the First Amendment, then Buckley's got to be reversed because it has no relationship to the First Amendment. And if women don't get the right to have their autonomy protected in the choice whether to have a child or not, then rich people don't get the protection of the Supreme Court in blocking efforts to make sure that they don't have an enormous influence inside of our political systems. Both of those results are consistent with what the framers of our Constitution would have said, and I think if it's one, it's got to be the other.
I think for a lot of listeners, especially younger listeners, they wouldn't necessarily think initially of Buckley when they think of campaign finance. They probably think of two more recent cases, Citizens United and as well as SpeechNow, which is a Supreme Court case. But can you kind of briefly walk folks through kind of what the key holding of Citizens United was and sort of what SpeechNow added to that?
Yeah, so you're right. It's incredible how many people know about and are outraged about Citizens United. Because what Citizens United did, from one perspective, was a tiny little addition to what Buckley had done 50 years ago. So 50 years ago, the question in Buckley was whether independent expenditures by rich people could be limited because the law purported to limit those independent expenditures. And what the court said was, well, our rule is you can limit it if there's a risk of corruption. And what we know about independent expenditures is that they only qualify as independent if there's no coordination between the spender and the campaign. And so if there's no coordination, there's no opportunity for any quid pro quo. And so if there's no opportunity for any quid pro quo, there's no risk of corruption. So if there's no risk of corruption, you can't limit that speech. Now, if it turns out that that independent expenditure by that rich person was coordinated, then what Buckley said is, well, the law says that's now a contribution, and that contribution is far in excess of the maximum contribution, so you violated campaign finance law. So like if Elon Musk comes into a campaign and spends $100 million of his own money, that's not Citizens United speech, that's Buckley speech, because that's just a rich person spending money independently of a campaign. And if he says it's independent, meaning he's not coordinated with the candidate, then what Buckley means, what the Supreme Court has interpreted the First Amendment to mean, is that he's allowed to spend as much money there as he wants. Okay, but if it turns out that in fact he did coordinate, if in fact he did talk to the candidate or the campaign and they strategized about a particular message, then that spending is not, quote, independent spending. Instead, that spending gets converted into a contribution. And if you made a $100 million contribution to a campaign, you violated the law that says the most you can give is, I don't remember what the current number is, but something like $5,400. Okay, and at that level, it's a felony, the amount of money that you had given in excess to a campaign. So the point is, it's regulated to say that it has to be and remain independent. Okay, what Citizens United said was, could the limits on corporations spending money independently of a campaign be constitutional? And from the perspective of this corruption-obsessed focus, from the Supreme Court's perspective, it was an easy question, because the question they thought was there any justification for the limit? And if there's no risk of corruption, for the same reason, it's got to be independent, meaning not coordinated, meaning there has to be a separation. And if there's not a separation, then it's a contribution, not independent expenditures. The court said, yeah, there's no constitutional basis for limiting a corporation or a union or a rich person from spending as much money as they want. That, from their perspective, seems to follow obviously. What triggered most people was rhetoric in the opinion that made it sound like the court was creating some kind of constitutional right for corporations, which of course are created by the state, and it seemed weird that we would be creating rights for that entity. Now, Justice Scalia, in his concurrence, said this kind of misses the point, because the question is not whether corporations have rights. The question is whether Congress has the right to limit this speech. And if you say that the only reason for limiting the speech is the risk of corruption, even if it's the corporation that, even if you don't think corporations have a constitutional right, still Congress can't limit the speech of those corporations. So I think that there was a lot of Sturm and Drang about the idea of corporations being given these rights, which of course reaches way back into the 19th century and has been a messy question from the very beginning. But I think in the Sturm and Drang about corporations, they missed a very important point about Citizens United. Citizens United was only talking about expenditures. It was not talking about contributions to a committee that would make those expenditures. And so the question of whether limits on contributions to those committees, which existed in federal law, still on the books, they were struck down in SpeechNow, were themselves constitutional or not. That question got taken up by the lower federal court in the D.C. Circuit 3 months after Citizens United was decided. And 3 months after Citizens United was decided, what the D.C. Circuit said was, well, if independent expenditures can't be limited because they create no risk of quid pro quo corruption, it follows as a matter of logic. The court said as a matter of law. In the law speak, that means as a matter of logic. We're not looking at the facts on the ground. We're just looking at the concept. It follows as a matter of logic that a contribution to a committee that makes independent expenditures also creates no risk of quid pro quo corruption. And that's the logical move, which I think is pretty obvious when you see it, that is false, just doesn't follow at all. But it's that logical move that created the Super PAC. It was denominated by that by a writer in the National Journal shortly after the opinion came down. And within a couple years, a couple other circuits basically said the same thing. If the expenditure creates no risk of quid pro quo corruption, then the contribution can create no risk of quid pro quo corruption. So you can't limit the size of the contribution, just like you can't limit the size of the expenditure. Now, that holding, again, I think was false when made, although not clear. It wasn't obvious. In fact, I didn't see it. I didn't get it originally. It took really great lawyers from Free Speech for People to get me to see it. But that holding is just wrong. And the clue to its error was revealed by one of my favorite senators, Robert Menendez from New Jersey. When he was indicted in 2015, he was indicted for bribery, quid pro quo corruption. And the bribe basically was he promised government favors to a Florida businessman in exchange for that Florida businessman making a contribution to Menendez's Super PAC. So there it was, quid pro quo corruption involving a contribution to a Super PAC. The very thing the D.C. Circuit said as a matter of law could not happen. And indeed, Menendez's lawyers had the chutzpah to argue that the thing he had been indicted for, the D.C. Circuit said was impossible, so therefore they should dismiss the indictment. And of course, that was just a joke, from the court's perspective, but it revealed the logical mistake in the D.C. Circuit's opinion. And since that point, there have been many people, Larry Tribe, Al Alschuler, Richard Painter, Norm Eisen wrote a really powerful paper to point out this logical mistake and to try to get courts to take it up and to consider the mistake, because there's nothing in the Constitution or in the Supreme Court's jurisprudence that should give us super PACs. But it's taken a decade to get to a place where we can actually tee this question up. And the Maine initiative is the vehicle that I think will give the court finally the chance to address it.
That word independent in terms of expenditures carries a lot of weight. And when I used to teach this in classes, there would sometimes be someone who was really paying attention and they would say, well, wait a second, how exactly do you know if they're coordinating or not? And I would say, well, I don't know. It's pretty tough, isn't it? And I guess it's just stunning to me that something that a half-awake undergraduate can pick up on like that is something that the Supreme Court seems to have completely rejected.
Well, I don't typically like to defend the Supreme Court, but I want to defend the Supreme Court here because I think that their opinion has just been misunderstood. I think what your undergraduate, I assume it's an undergraduate. Yeah. So what your undergraduate is identifying is an absolutely true question. How do you know it's actually independent? And the Supreme Court was not saying it is necessarily independent. The Supreme Court was saying if it is independent, then there's no risk of quid pro quo corruption because there's no coordination, so therefore no opportunity for a quid pro quo. Put it the other way around. If there's a quid pro quo, it's not independent. Now that raises the question, how do you know? And one problem we have is we don't have an effective police force that's looking at campaign finance violations. The FEC has basically been neutered by the president by not even having sufficient appointees to do its work, and it doesn't do any effective policing in this space. But if you had a real FEC that observed Elon Musk spends $20 million in this race, claiming it's independent, and then does some investigation to make sure that, in fact, it is independent, so that the committees know that if, in fact, they are not independent, they're going to face significant fines, then, practically it would be independent as well as logically independent. But I think it's really obvious that even though logically it is independent, practically it's not independent. It's really impossible to believe that what Elon Musk did in the 2024 election was independent in the relevant sense, right? It beggars belief. And so that's why I think people are so skeptical about this whole line of jurisprudence, which, maybe the court should have recognized and said more to say, look, what we're saying is logical, not practical. We don't have any factual findings before us to actually make this conclusion. So we're not saying that everybody is doing exactly what they're supposed to be doing. But what we're saying is, given the structure of regulation, and Buckley was actually better about this, because Buckley, unlike Citizens United, explicitly considered the case where somebody says they're independent, but they're not independent. And they said, well, if that's true, then the expenditure is a contribution. And so therefore it would be a violation of contribution limits. And so I think that if you understand them to be saying something very narrow, you should be able to say, okay, conceptually I get it, but now we need to have a real FEC that's actually making sure that there is actually independence here. Another way to think about it is, and I think this brings out the mistake in SpeechNow really clearly. If you wanted to set up an independent political action committee, it's pretty clear what you tell the staff of political action committee. It's clear, you say, here are the people you can't be talking to. Here's the way in which you can't be engaging with the campaign. And if any of you do this, we're going to fire you. Here's what we need to do and be able to certify so that we can say there's no coordination, so we can qualify as an independent expenditure committee. But if you are an independent expenditure committee and you receive a check for $10 million in the mail, you have no way to know what happened to produce that check. There's no policing that you can do of that check. You can call the guy up and say, did you talk to the candidate before you sent us this money? And of course, he's going to say no, but there's no real way to know that there's a structure in place to avoid that kind of coordination. And indeed, this is the big difference. With the expenditure, there's a set of regulations about the coordination. There's rules about coordinating. With the expenditure, with the contribution, there's no such rules. There's a rule that the FEC has divined, which is not clear where it comes from, which basically says a candidate at a fundraising event for a Super PAC can't ask people to contribute to the Super PAC more than the maximum contribution they're allowed to contribute to the campaign directly. But there's nothing that controls whether, the donors to the Super PAC talk to the candidate and have some coordination with the candidate in the process of making their donation to the Super PAC. It's just not policed. And it's not policed not because somebody didn't think about it, but because constitutionally it would create an enormous burden on free speech if you tried to police the way in which donors interacted with candidates. I mean, this is just, not the sort of thing that you can imagine the government policing. So the cheaper way to avoid that kind of problem is just to create a limit on the size of the contribution. So if I know the most you can give to my independent political action committee is $5,000, I'm not going to be suspicious that, a candidate's selling their vote for decisions for $5,000. We've not gotten to that level. I mean, the allegations against the president for selling pardons are all in the $1 million range, not in the $5,000 range. So I think that creates a condition where people could believe corruption is not going on. And that reality, I think, can be well policed in the expenditure side, the Citizens United side, but it makes no sense in the context of SpeechNow, which has no mechanism to police and couldn't constitutionally have a mechanism to police.
So let's talk about this Maine case. I mean, the law, Maine voters passes by, I believe, almost a 3-to-1 margin in 2024, and it capped Super PAC contributions. And so can you talk a little about why reformers in Maine pushed for this law, and then why opponents almost immediately challenged it in court, and I guess finally why you felt this was a really good vehicle for kind of maybe pushing for some change in this area.
Yeah, so it's actually kind of accidental that it ended up in Maine. I had been working, my group, equalcitizens.us, had been working with Free Speech for People to try to tee up an initiative in Massachusetts. And the initiative in Massachusetts has to be approved by the Attorney General, and the Attorney General blocked the initiative, saying that it violated the First Amendment for SpeechNow-like reasons. So then we could challenge that, and we challenged that in the Supreme Judicial Court, which is like the Supreme Court of Massachusetts. And really just awful decision by the Supreme Judicial Court basically said, we're not going to resolve the First Amendment question. We're instead going to say that you need to gather signatures for the initiative before you can challenge the Attorney General's determination about the First Amendment, which means it's basically $1 million filing fee. Like you've got to spend $1 million to gather signatures to be able to challenge what we believe is an illegal ruling by the Attorney General. Then there's no such thing as $1 million filing fee in our legal system. It's just it's an outrageous decision by the Supreme Judicial Court that protects the Attorney General to basically say whatever the Attorney General says, unless she's going up against a major corporation or somebody with endless money, that's the final statement. So I was at a dinner which included a bunch of people from Maine, in Maine, obviously. So it was a bunch of people in Maine who were having a dinner to talk about democracy reform issues. And one of the people at that dinner was a guy named Rick Bennett, who at that time was a Republican state senator from Maine, but who had been an enormously important reformer for money in politics. He had been behind question 2, which had just been on the ballot, which limited foreign governments from having any participation in Maine initiatives. So he had been the leading proponent for that. And I just told the story of what happened in Massachusetts. And Rick said, we should do it in Maine. And when he said that, I was like, that makes a lot of sense because number one, Maine doesn't have this pre-clearance system where the Attorney General gets to block an initiative before the people pass it. So we wouldn't have to worry about convincing lawyers that this was constitutional. And number two, Maine is a much better place to bring this initiative than Massachusetts because, if Massachusetts passes it, everybody says, well, of course, the blue state Massachusetts passes it. But Maine is a deeply purple state. And so if Maine passes it overwhelmingly, people get that this is not a partisan issue. So I said we would try to do that. And so Equal Citizens raised the money to be able to get the initiative on the ballot. Meaning to gather signatures. We then stepped back from the campaign because my view was Mainers ought to fight about whether to pass the initiative or not. We shouldn't be from outside of Maine trying to direct that campaign. So there's a great committee in Maine that stood up the fight to pass it, and they were extremely successful. And for obvious reasons. I mean, like I gathered signatures on Election Day 2023 in a tiny little town called Hollis, Maine. And the first guy to come up to me said, I'm here gathering signatures to get Donald Trump on the ballot. What are you here for? And I showed him the initiative and he read it and he said, hell yeah. And he signed the initiative and he said, I'm going to get everybody signing my petition to come sign your initiative as well. And then for the couple hours that he was there, that's what he did. All these Trumpers came over and signed the anti-Super PAC initiative because everybody believes this is a corruption of our system. It's not left versus right, at least at the grassroots layer. I mean, Washington is filled with a lot of Republicans who think that, like Mitch McConnell, who think it's essential to have this power. But, at the grassroots layer, everybody believes this is corruption. So it wasn't surprising to me that, I don't want to exaggerate, it wasn't 3/4, it was 74.9% of voters who supported this initiative. And that's because everybody looks at the system and says it's outrageous. Now, Maine has suffered this a lot because it's a purple state. You constantly see this outside money coming into Maine to get candidates to win. So in the Susan Collins race 6 years ago, there's an endless amount of outside money that came in. In the Jared Golden race in 2024, there was an endless amount of money that came in from the outside to try to block him from winning. So Mainers are very sensitive to the fact that Mainers are not allowed to run their own election. And Rick Bennett, who now is like an independent candidate for governor in Maine. But Rick Bennett was quite compelling in talking about how this outside money made it impossible for Maine candidates to run the kind of campaign they wanted to run. They were almost a sideshow. They couldn't afford to get on television. They couldn't afford to get their message out. And even if they got their message out, that's not the message that anybody was talking about. It was the message being driven by these Washington-based super PACs. So in the Collins race 6 years ago, it was one of the worst negative ads campaign, because negative ads are what super PACs love to run. And it just made everybody feel icky about the process. Whereas I think, I don't support Susan Collins, but I'm sure Susan Collins and Sarah Gideon would have had a much more constructive race, like talking about positive issues that they had to offer Mainers than you actually saw because of these super PACs. So I think that's what made Maine a perfect place to bring this. So we brought it. The Mainers ran the campaign. They won almost three quarters of the vote. And then, as we expected, because this is the plan, immediately it was challenged by two super PACs that are both basically funded by Leonard Leo, who's also a Mainer, but or at least his summer house is in Maine. And Leonard Leo is one of the most important conservative super PAC people in the country, and they realized they needed to strike this down. And I think what's so interesting about this case is that 99% of lawyers, when I describe this to them, are like, yeah, no, you're wrong. There's no way the Supreme Court is going to strike down super PACs. It's not going to happen. Indeed, our lawyer in the case, Neil Katyal, the guy who got tariffs struck down, I've known him forever, and I tried to get Neil to take the case. Kept on calling him. He kept on avoiding my calls. Finally, I got through and he said, look, Larry, I don't take loser cases. I've got, not enough time. I'm just going to, I only do winners, so I'm not going to do this case. It's just a waste of time. And I said, Neil, just have lunch with me, just one lunch. And so he took me to the worst restaurant in Washington. And halfway through the lunch, he was like, holy shit, I think you're right. I think I can win this case. And it's because it just takes a lot to get people to see not just the law, but the politics. Yeah. It's not just that legally we are right, which I think nobody has shown why legally we're not right. We're clearly legally right. It's the political point. So the political side is, number one, people need to realize super PACs are not just a Republican thing. Indeed, I think, one of the biggest reasons Kamala Harris couldn't cut through to the ordinary voter is that she was bound by the positions of the $300 or $400 million in super PAC money that she had raised, right? So Democrats are maybe not quite as good, but they're pretty good at raising super PAC money like Republicans are. So this is not a partisan advantage to Republicans over Democrats. That's number one. And number two, from an institutional political perspective, people like my friend Bernie Sanders have been going around for the last 16 years saying Citizens United is the worst decision in Supreme Court history. It's a total disaster. The only way we're going to end super PACs is by overturning Citizens United. Now, I've criticized Bernie for saying this because, well, first, it's not true. But secondly, it convinces people there's no reason to fight because the Supreme Court's not going to overturn Citizens United. If you think the Supreme Court's going to overturn Citizens United, you just don't understand the Supreme Court. Maybe if they were consistent originalists, they would overturn Buckley and Citizens United, maybe, but I don't see that's going to happen anytime soon. So it's both strategically and legally wrong. But I think that gives a gift to the Supreme Court because I'm sure that Chief Justice Roberts would love to write an opinion. People say Citizens United is the worst decision in the Supreme Court history, see Bernie Sanders, but we disagree. We reaffirmed Citizens United. Citizens United was perfectly consistent with our longstanding doctrine about corruption and quid pro quo corruption. But nothing in Citizens United limits the ability of a state like Maine to limit the size of contributions. Why? Because contributions do create a risk of quid pro quo corruption. And there are amicus briefs in our case. You can actually go to Amazon. There's a great book that we built called Friends of a Corruption-Free Government that has all of the amicus briefs in our case by like the Brennan Center and Campaign Legal Center and a whole range of people, including a bunch of billionaires like Mark Cuban and Reid Hoffman and Steve Jurvetson, who joined all to say that they thought super PACs were a destruction for our politics. But all of these amicus briefs pointed to the endless examples like Robert Menendez, of Super PAC money corrupting the political system. And so I think that the Supreme Court could easily say Citizens United, perfectly fine. SpeechNow is clearly wrong. Yeah. And so therefore you can limit contributions, meaning you can eliminate super PACs, even if you're not going to be able to stop Elon Musk from spending money independently. You should police his spending. You should make sure he's not in bed with the candidate that he's trying to spend money for. But, it's reality of the way the court has interpreted the First Amendment. That follows as a matter of logic. But SpeechNow is not consistent with that logic.
Yeah, and I think what a lot of people don't recognize is that, in fact, SpeechNow isn't a Supreme Court precedent. And what I think is really clever and really caught my attention about your approach here is that you're not going in saying, well, your precedent is wrong, you should overturn it, but essentially arguing that this is okay and you don't have to overturn any of your previous precedents, which I think is a really smarter political approach.
Well, right. I mean, it's not just that we're saying you don't have to overturn it. What we're saying is apply the logic of Citizens United. Like, we embrace Citizens United. And, a lot of people are like, oh my God, how could you embrace Citizens United? And, I think that people have got to understand what it is to be a lawyer arguing for your client, right? You accept the basis of the law as it is. And you ask, do the tools the court has given you give you an opportunity to prevail for your client? And sometimes, I think this argument about why Citizens United and Buckley should support the outcome that we're arguing for is a relatively easy argument to make. But we've gotten a lot of political pushback because the real reason Neil Katyal is allowed to be in the case, the Attorney General of Maine is defending the initiative as well. So why are we in the case? Well, it's because the Attorney General of Maine did not want to make the other argument that is central to why we should win, which is the originalist argument. The Attorney General of Maine doesn't want to be, an originalist, doesn't want, for political reasons, to advance the originalist argument. Well, I get that. The Attorney General is like a political position, not directly elected, but, in the context of keeping his electors happy, I understand why he doesn't want to make that position. And indeed, when we tried to stand up the argument in Massachusetts, the reason that we had to partner with Free Speech for People is that Free Speech for People also didn't want to make the originalist argument because they don't like the originalism as an argument. But my view is, look, 6 justices of this court say that they are originalists. And you might not like that or not, but, they're the one with Article 3 tenure. They're the one who have been appointed by the president after the nomination of the president and confirmation by the Senate. So agree with them or not, the question is, in their way of looking at the world, does your client win? And one of the other heroes, from my perspective, in making this case feasible was Josh Hawley, who in October of 2023 introduced a bill in Congress to overturn Citizens United. And what was his argument? His argument was, as any good originalist knows, nothing in the original meaning of the First Amendment would have limited Congress's ability to control how corporations spend their money. Flat out, period, end of case. And what Hawley is saying is right. Nothing in the original meaning of the First Amendment should limit the ability of Congress to regulate how corporations spend their money or what the size of a contribution to an independent political action committee is. Nothing in the First Amendment would restrict that because of the way the framers thought about the First Amendment. And so the second argument that's in this case that Neil is going to be advancing is, to those originalists, have some courage of your convictions. Like, look at your originalism and ask, what does my originalism say about this case? Because it's no surprise that Buckley versus Vallejo in 1976 didn't think about the original meaning of the First Amendment. That court, the Berger court, had no patience for originalism. Like, originalism was not a thing in the 1970s. It began to be a thing because of Robert Bork, but in the 1980s, Justice Scalia is appointed to the Supreme Court. Then originalism begins to have real presence in the Supreme Court. But in the 1970s, is not what anybody was thinking about. So, okay, they are declaring themselves to be originalists. Be consistent in your originalism. And if you are consistent in your originalism, you will say that you could say Buckley is not constitutionally compelled. Now, what I'm actually hoping happens, because I think a huge change like overturning Buckley might be too much for this court, what I'm hoping happens is that there are justices on this court, Amy Coney Barrett, Justice Gorsuch in particular, who are trying to demonstrate that their version of originalism is consistent and principled. And I have some experience with this because I clerked for Scalia at the stage of his career where that's what he was obsessed with demonstrating too. And indeed, the last time I saw Scalia, I had lunch with him in late 2015. And Scalia, I said to him, you ruined me as a law professor. And he said, what do you mean? And I said, well, I clerked for you. There are any times where there was the originalist thing to do and a conservative thing to do. And not immediately, but eventually you always came around to the originalist thing. And I said, so when I became a law professor, whenever there was that conflict, I predicted you would do the originalist thing. And I said, you let me down every single time. And so he laughed and he said, give me an example. And I talked about campaign finance. And by the end of the lunch, now, he was a person who imbibed, drank during lunch. So he bought, it wasn't really what exactly, his committed view was. But by the end of lunch, he was willing to say, geez, I hadn't really thought about it like that. Maybe I can restrict what Congress can do to this particular conception of corruption that has no relation to what the framers actually thought. And so, this kind of has ruined me as a law professor because it has made me believe that these justices with these theories can be brought to see the consistent implication of their theory and have a courage of their conviction. Now, you could be Amy Coney Barrett and say, wow, geez, maybe originalism shows that we've gone off on a frolic and detour in this space, but I'm not willing to overturn Buckley at this point. That's too unstable, but at least it should give me a motivation for reading Buckley in a consistent way and allowing them to restrict the size of contributions because there is a risk of corruption there. That seems to be a perfectly legitimate move for her to make. And that's the move that we're going to appeal to. And that's what Neil will be appealing to as he tries to make it clear to them that they can't, consistent with their originalism, support this kind of made-up doctrine of Buckley, even more extreme doctrine that would say there's nothing you can do to restrict the way in which campaigns happen in America.
When I hear you explain that strategy, and especially when I think about originalists on the court who are willing to ignore decades or sometimes generations of precedent, honestly, the first name that comes to mind to me is Clarence Thomas. It seems almost like designed to appeal to what he claims to be his originalism and maybe a little bit less Justice Alito. And then I'm starting to count votes and I say, okay, the court's 3 liberals and those 2 sort of uber originalists. But yet I have this funny feeling that this argument might not be as convincing to say Justices Thomas and Alito as I, or maybe you feel it should be.
Yeah, I mean, I see it the same way you do. I don't have a good explanation for it because, Justice Thomas is the one who has been trying to overturn New York Times versus Sullivan, one of the most important, famous Supreme Court First Amendment cases, securing to journalists an immunity from defamation lawsuits where their mistakes are good faith mistakes. He's been trying to overturn that, and his argument has been a flat-out originalist argument. So his position is, what would the answer have been in 1791? And whatever that answer is in 1791 needs to be the answer today. So on the one hand, he is open to applying originalism in the context of First Amendment doctrine, but he is one of the most extreme libertarians when it comes to campaign finance. And I don't see how those two can live together because the very same method of reasoning, indeed, the very same scholars that he cites, like he cites Judd Campbell, who's one of the leading originalist scholars at Stanford University. He cites Judd Campbell's work to support the idea that New York Times versus Sullivan is inconsistent with the original meaning of the First Amendment. Okay, well, let me show you the pages in Judd Campbell's work that demonstrate that the Buckley versus Vallejo conception of the First Amendment is also inconsistent with the original meaning of the First Amendment. I mean, in his cases about New York Times, he says that New York Times versus Sullivan is just policymaking dressed up as constitutional law. And when I read that for the first time, I thought, have you read Buckley versus Vallejo, Justice? I mean, there's no clearer case of like the court feeling like it's Zeus standing on Mount Olympus declaring these ideas of what the First Amendment ought to be than Buckley versus Vallejo. And so I think consistently, if I could have a chance to talk to him, I don't have that relationship with him, I would say, what the hell? How can you have it one way in this context and not in the other context? Now, but the point is, I think we're going to get 7 votes. And I'm not counting Justice Thomas and Justice Alito, assuming they're on the court when this eventually gets to the court. I think the real chance is, Chief Justice Roberts will see the argument. He will also see the institutional benefit that he gets by saying, we support Citizens United. We're not Citizens United one iota, but nothing in Citizens United entails SpeechNow. It's just a mistake. And, oh, by the way, everybody loves this decision. So, celebrate with us. But I feel like we're giving him a gift. We're saying, here's a way for you to save face completely. The world looks at you and says, you guys have created this mess, but you didn't create this mess. It wasn't Citizens United that created this mess. It was SpeechNow. So you get to say, Citizens United's fine, but SpeechNow is gone. And so therefore, the state of Maine and the federal government can limit the size of contributions to independent political action committees. That's consistent with the First Amendment. So I think he's a very solid opportunity. And then the question is, the two, what I think of as, and I mean this in a charitable sense, the Scalia wannabes in the best possible sense. These are originalists who are trying to demonstrate their originalism is principled originalism. Gorsuch and Amy Coney Barrett are 2 other potential votes. The other potential that decided SpeechNow. And if you read that oral argument, there's one exchange he has with a lawyer where the lawyer makes a fundamental mistake. And the mistake the lawyer made was, Justice Kavanaugh basically was asking about the intuition that your student had. He was basically saying, why are these independent expenditures really independent? And so the lawyer says, well, it could be that there's a quid pro quo behind the independent expenditure. And he says, well, yeah, but, still they're constitutionally protected. And the lawyer says, yes. Well, the lawyer should have said no. That was the wrong answer. The lawyer should have said, no, Justice, they're not constitutionally protected. Because if there's a quid pro quo, it's not uncoordinated. And if it's not uncoordinated, then it's a contribution. And if it's a contribution in excess of the maximum contribution limit. So you've committed an offense, and if it's big enough and with intent, it's a felony. So felony law regulates that expenditure. And this was just missed by the lawyer, which allowed them to think that the messiness your student identified was an excuse for ignoring the obvious potential for corruption on the expenditure side. So therefore, it's an excuse for ignoring the obvious corruption on the contribution side. But so the question is whether Kavanaugh is willing to think through the implication of it enough. And, I have a little faith that he will. Again, I'm like the last naive law professor, so people laugh at me when I say stuff like that. But, I think that I think we get 7 votes.
I think there's an important distinction to be made between sort of old-fashioned bags of cash, quid pro quo corruption from what I've called, and I totally stole this from you, open and legal corruption, right? No one's handing over gold bars. No one's saying, hey, vote for me on this and I'll contribute to your campaign. I mean, that almost never happens. And you, for a long time, have said, hey, the quid pro quo corruption is not the real corruption problem. It's what you've called dependence corruption. And it seems to me that a lot of people, it's weird to me that the Supreme Court does not seem to want to understand this basic argument when, as you point out, vast majorities of the American Republic from both sides of the aisle think absolutely Congress is bought and paid for. And so can you talk a little bit about why you think there's this resistance, especially it seems on the courts, to kind of recognize this very real open and legal dependency corruption? Do you think it's just the justices not wanting to overreach in some way, or what else is going on, do you think?
Well, I don't think it's a desire not to overreach, because I think that the jurisprudence is quintessential overreaching by the Supreme Court beyond what the Constitution tells them they ought to be doing. I think what they're doing is that they're just following, Mandarin-like, they're following the rule that Buckley gave them, and they interpret corruption in Buckley extremely narrowly. I think it could have been possible to read corruption in Buckley more broadly, not as exclusively about quid pro quo, but as a paradigm case quid pro quo. And you could have thought of other kinds of corruption too. But they've narrowed it. Chief Justice Roberts has been really insistent in narrowing it. And then they've applied this narrow principle again and again. And so the first thing to say to them, which again we talked about at the beginning of this podcast, was what the hell? Where do you get the right to do this? Like, by what authority do you get to inject into our Constitution a value which is not in the Constitution? Like, where does that come from? Especially when you're resisting the Democratic legislature or the people of the state of Maine. You have no right to do that. So sit the frick down. Like, stop being these judges who think that, Plato crafted the Supreme Court. Like, you're not the guardians of our republic. You are supposed to be interpreting our Constitution. And if we the people say something, okay, fine, interpret it. So we the people said 2 senators per state. It's a stupid idea. Madison was against it, but we said 2 senators per state. And so California has a wildly underpowered representation in the Senate. It's a terrible idea. But if the Congress tried to get around that somehow, the Supreme Court should say, no, I'm sorry. That's what the Constitution says. We, the people, have said 2 senators per state, and we're going to enforce that against any state, any legislation to the contrary. But here, we, the people, never said the only basis Congress has for regulating integrity in our political process is the risk of quid pro quo corruption. That's nowhere in the minds of these justices, of the framers of our Constitution or any time in our history. So the first point to say is that narrow conception is baseless. And then the second part, which again goes back to the originalism, is to say, okay, well, what did the framers think corruption was? So I did an amicus brief in the McCutcheon case, which was a very important case about aggregate limits of contribution. And I thought that there was no chance that they were going to strike that down on quid pro quo basis. So I said, they ought to be thinking about another conception of corruption, which was consistent with the original conception of corruption. And that argument had never been made to them before. And so we went back to the framing context and we gathered every single use of the word, quote, corruption at the time. And what we found was the overwhelming majority of uses of the word corruption, not about quid pro quo corruption. They weren't worried. I mean, of course, they thought bribery was corruption, but that's not what they were worried about. They were worried about institutional corruption. They were worried about corruption of the institutions of democracy. So their paradigm case was the British Parliament. They said the British Parliament was corrupt. It wasn't corrupt because there was bribery. Maybe there was bribery, maybe not. I'm sure there was. But that's not what they were worried about. Right. What they were worried about was a system where the king, the crown, could essentially appoint members to parliament because they controlled these rotten boroughs. And through the control of the boroughs, they basically could have their people in parliament. So here was a system that was to be dependent on the people of Britain who were to, it's a terrible system for electing because not many people got to vote, but whoever got to vote, they were the people who were supposed to be constituting parliament, not the king. It was supposed to be independent of the king, but it wasn't independent of the king. It was dependent on the king, and that dependence was improper. So that improper dependence was a corruption of the design of parliament. That's what they meant by corruption. Now, Madison in Federalist 52 tried to explain what at least the House of Representatives would be. The Senate at that point was appointed by state legislatures, but the House of Representatives was elected. And Madison in Federalist 52 says that the House of Representatives would be, quote, dependent on the people alone. So an exclusive dependence on the people. And in Federalist 57, by the people, he says, he means, quote, not the rich more than the poor. Okay, so an exclusive dependence on the people, not the rich more than the poor. Well, look, the system we have for funding campaigns right now is exactly the opposite of that. Yeah. You can't run for Senate in the state of Georgia or in the state of Massachusetts or wherever there's a competitive race at least, without relying on the big funders to come in and fund your campaign. So the first primary is not the primary between inside the Republican Party or the Republican or the Democratic Party. The first primary is a money primary. You've got to win the money primary. You've got to convince the people with big money to come in and support your campaign. Otherwise, you don't have any shot. Okay, that's a dependence on rich people. And rich people more than poor people, more than ordinary people. So we have created exactly the opposite of what Madison was describing. And in that sense, I say that's a corruption of the framers' design. It's not an individual corruption. It's an institutional corruption. And so even if there's zero quid pro quo corruption, even if there's no bribery in Congress, this way of funding campaigns is a corruption of Congress. And that corruption should mean that Congress should have the ability to eliminate that corruption if you think that the only basis for limiting campaign speech is quote unquote corruption. So that argument I have always thought is the most important for the court to get to. But again, the litigation strategy is slightly different from the conceptual strategy. Either way, you get to the same answer, that legislatures or the people of Maine ought to have the freedom to limit super PAC.
I guess it sort of seems to me, I think you're right on most of, just about all of this, honestly. But it seems to me that money will always find a way. So what I mean is, as long as running a successful campaign costs millions or tens of millions of dollars, it's like playing whack-a-mole, basically. That money's always going to find a way to flow into the campaign. And so, which is why I've always been a big fan of your much more fundamental calls to fundamentally change the system. There's a thing in the Republic Law you talk about you call it the Grant and Franklin Project. And to me, it seems like if we really want to deal with money in campaigns and change the reliance from the rich to the 0.001%, whatever, to the people, we really need to do something more like that. I don't know if you're still a fan of that idea. I was when it came out. But do you still think that's the right way to go, to kind of basically give money to the people so they can kind of swamp, or ideally swamp, those kind of rich corporate donations?
Yeah, this is an idea that Rick Hasen has talked about, and Bruce Ackerman and Ian Ayres have talked about, and which I talk about in that book is democracy vouchers. You basically give vouchers to citizens that they can then give to candidates to help fund their campaign. And those vouchers would then change the dynamic of fundraising, because instead of like having cocktail parties with super wealthy people, you would be having block parties with everybody in your district, as many of them as you can, and trying to collect vouchers from ordinary people, which means you'd be responsive to the people, not responsive to the super wealthy. And I think that's a critical part of reform. It's just politically very difficult to get jurisdictions to embrace this solution so long as super PACs are on the field. Now, I think if you look at Mondami's victory in New York, it's really illustrative because, first of all, he was a very vocal opponent to super PACs. I mean, he made the issue in the campaign as it related to Cuomo, the whole super PAC issue. Like, look at all the money this guy is getting from these super PACs. Who really is calling the shots? And that was very salient to voters in New York, just like it's salient to voters everywhere. But he could afford to do that because there's public funding in New York. Right. He has a matching fund system where he very quickly reached the maximum amount that he could raise and therefore that he could get from the city. And he started issuing, ads that said, please stop giving me money. Give money to other candidates. I have everything I need. And what it demonstrated was that you don't actually have to have the most money. You just have to have enough to be competitive. And if you're competitive and the other side and the public can understand your position, it's enough to give the campaign, if you're good, the money they need to actually succeed. So I think the ultimate solution has got to include some version of public funding. And I think that the vouchers is better than matching funds, because even matching funds is narrowing the field of funders to those who have $100 or $200 to give to a campaign. And, the reality is the vast majority of Americans don't have that kind of money to give to a political campaign. But in Seattle, which has adopted vouchers as a solution, Seattle voters get 4 vouchers for $25 each, which they can use to help fund city elections. And that's radically changed both the source of money coming into those elections, but I think more importantly, the kind of candidate that can run, because in the system we've got right now, where you got to raise money from what we used to call a Rolodex, but basically you've got to have contacts who have $5,000 to give your campaign. The kind of person who is most likely to be able to run that kind of campaign looks like me.
Yep.
It's a white male lawyer. Those are exactly the demographics of the sort of a person who's going to have a list of 1,000 people who could afford to give $5,000 to run a campaign. But if you're, a blue collar worker or a teacher or a mom or any other occupation that doesn't have this kind of list of wealthy people who are likely to support your campaign, you can't compete. But in a voucher system, anybody competes at an equal level. So you show up to a block party and you say, here's my vision for making it so that we have childcare to take care of kids so that moms can afford to work. Bingo. To the people for whom this is an important issue, they're willing to hand over their voucher because they can't do anything else with their voucher. Yeah. It's only to fund campaigns. So I think this is a much more democratic way to help fund campaigns, both in the sense that anybody can fund and in the sense that it inspires a wider range of people to be candidates. And that's what Seattle has seen. They've seen an increase in the diversity of candidates and an increase in the diversity of funders, which is making their system closer to the ideal system for funding campaigns than anything else we see anywhere else.
Final question for you. Some people might look at the landscape and say, especially at the national level, that the last real meaningful step forward in some ways for campaign finance reform would be McCain-Feingold. That was almost a quarter of a century ago in a very different political world. And when you look around at the overall environment, what is it, if anything, that gives you sort of cause for at least some optimism?
Well, people forget, but we came within 2 votes of passing the most important democracy reform package, I think, since the Civil War. John Sarbanes was the real architect behind this. And he convinced Nancy Pelosi to take up this as a cause in the 2018 election. And she promised if the Democrats gained control of Congress, they would pass this as H.R. 1, the first bill that they would pass. And indeed, she delivered on that promise. She got every Democrat to support it. No Republican supported it, but every Democratic supported it. And then she promised to do the same thing in 2021 if indeed the Democrats once again controlled Congress. And in 2021, because of the victories in Georgia, the Democrats controlled both the House and the Senate. And so she again passed it. And then the challenge was that it was subject to the filibuster. And so the question was whether you could get enough Democrats to modify the filibuster rule, because, the filibuster rule is not in the Constitution. Mm-hmm. It's just a rule of the Senate. It's been modified for all sorts of cases like judges' appointments and the like, or the budget reconciliation. So the question was, can we make democracy reform one of the exceptions to this filibuster rule? And Senator Manchin and Senator Sinema rejected that modification. So they voted against the modification, which meant there wasn't enough votes to change the rule, so therefore it died because of the filibuster. Now, I'm an opponent to the filibuster. Even in this administration, I'm an opponent to the filibuster. This might be the one thing that Donald Trump and I agree on. There should be no filibuster, period. I understand why people are happy there's a filibuster. And as my colleague has sort of pushed this idea of a modification to the filibuster to reflect the fact that, the majority of votes in the Senate doesn't necessarily represent the majority of citizens. Sure. So that proposal is that the filibuster be modified to say that you have a majority of votes representing a majority of the citizens, and if you do, then you can stop debate and vote on a bill. But the reality is the way the current filibuster works, for almost all bills except for budget reconciliation, you need a supermajority, 60 votes, to get that bill through Congress. And what 60 votes means is 41 votes can stop any bill. And this is a veto, a permanent veto. There's no overcoming. If the Senate doesn't pass a bill, it doesn't pass. So take 41 votes. How could you put together 41 votes? Well, if you take the 21 smallest states that supported Donald Trump by at least 10 points in 2016, that would give you 42 votes. Those 21 states would represent 21% of America. So the point is we have a system in the Senate where 1/5 of the country gets to veto any legislation, which is outrageous because that's exactly the system that the Articles of Confederation had. We thought we had to abolish to get the Constitution so that the majority could rule. But Congress has recreated the Articles of Confederation to basically mean that the supermajority is needed to do anything, which means a tiny minority gets to veto anything. But the point is, we came within 2 votes. And I'm confident that if the Democrats take control of Congress and in 2029, and the president is a Democrat, they will pass it again. And that bill addressed public funding of elections. It also ended gerrymandering. It also ended vote suppression. The John Lewis voting rights bill was part of the package. It also created an ethics rule for the Supreme Court. And I'm sure they will add some other things too, maybe like term limits for the Supreme Court. But the point is, I think the Democrats are committed, and I hope some Republicans begin to join this as well. Now, in the Senate, it was hard to be a Republican supporting changing money and politics rules because Mitch McConnell was so committed to the libertarian view here. So there's nothing he was going to do. But I think that there's a chance that if the Democrats take control, they will pass this bill and we will accomplish huge reform. We still need to solve the Super PAC problem, which is why I think this litigation is critical, regardless of whether Congress passes the For the People Act. But we could do something substantial, much more important than McCain-Feingold. I mean, I love that they passed McCain-Feingold. I think former Senator Feingold is a friend, and I think what he did was extraordinarily important. And John McCain, of course, was a hero despite the president's slanders. So I don't mean to diminish that, but that is small compared to the For the People Act. And I think that's on the table.
All right. Well, on that note, we will close. Larry Lessig, thank you so much for taking the time to talk with me today.
I'm really grateful for the chance. Thanks.
Thanks for listening to this Politics Guys interview. If you have a question or comment for us, we'd love to hear from you. You can reach us at mail@politicsguys.com. If you're not already a supporter of the show, we hope you'll consider becoming one. Supporters get ad-free versions of everything we release, our full-length midweek episode instead of just a preview, and access to our Politics Guys Discord group. It's a fun place with a great bunch of people. You can support us on Patreon, where you can even sign up for a free trial. And if Patreon isn't your thing, or you're a current supporter and want to give us a little extra one-shot contribution, you can support us on PayPal and Venmo too. You'll find links to all our support options at politicsguys.com/support and in the show notes. If you'd like to get our full-length midweek episodes, but you're not in a position to financially support the podcast right now, just email me. I'm at mike@politicsguys.com, and I'd be happy to get that set up for you. And whether you're a supporter or not, we'd appreciate it if you could subscribe, rate, and review us on whatever podcast app you use, as well as sharing episodes on social media. And finally, a very special thanks to our wonderful executive producers. They are Wilma Moreno, Daniel Toe, Ryan Beasley, Don Oglesby, Derek Schmidt, Dakota Heath, Jason Chrysler, Dave Dean, Jeremy Larson, Brian Matza, and Jody Marie Miller.
This podcast is part of the Democracy Group,